Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's discussion. In this week's discussion, we're in session number 4 of our new program entitled Update on Trends in the Cumulative Trauma Injury Claim. And by now, you're starting to get an understanding of the big picture and the drivers of the glut of cases that you're getting with an allegation of at least a component of a cumulative trauma injury. And it's this big picture that helps us to understand what is our role as a qualified medical evaluator. So up until this point in time in this program, we've laid some important foundation for your understanding of these sometimes difficult to wrap your head around types of cases. And from here on out, throughout the remaining 3 sessions of this program, I want to build on the concepts that we discussed in the first 3 sessions and provide you practical examples that you can use the next time you get a case that involves a cumulative trauma injury or an allegation of a cumulative trauma injury, so that you'll have the tools that you need to be able to understand what's operative behind these claims and what is your role as the qualified medical evaluator, and how you can quickly and accurately and profitably bring this report in for a landing so that you can be efficient and profitable on these particular types of cases. But before we get into the topics of today's discussion, let's just briefly review where we've come from so far in this program. In session number 1, we spent quite a bit of time talking about what actually constitutes injury, as injury is defined in the California workers' compensation system. And this is important for you to understand, because as you sit face to face with an examinee and you're deliberating over the question, does this examinee have or does this examinee not have a cumulative trauma injury? The most important principle for you to rely on and for you to understand is that in order to have a cumulative trauma industrial injury, there first has to be an injury. Without an injury, there can be no industrial injury, and there can be no cumulative trauma industrial injury. So it's interesting because injury is very carefully and specifically defined in the California workers' compensation system. So your first directive in these evaluations is to ascertain the presence or the absence of injury. And injury is very, very specifically defined. When the boxes are checked and you identify an injury, then the next step in the sequence gets enacted, and then you then have to determine whether or not that injury qualifies as an industrial cumulative trauma injury. But first and foremost, and most important of all, is to first establish the presence or the absence of an injury. If there's no injury, then you can quickly get this report off your desk with an opinion against AOE, COE in those cases that involve denied allegations for cumulative trauma injury claims. So we spent quite a bit of time on that, and it's always important and helpful to remind yourself of those principles, because those principles regarding injury will serve you when you're confounded on these cases. You can always come back to the concept of injury, and that concept will help you get to the naturally right conclusion every single time. And then in our second session, we started to talk about the distinctions between specific injury claims and cumulative trauma injury claims. And we talked about the necessity of proper reporting of these claims. Proper reporting of these claims is described in 2 labor codes sections 5400, and then also most specifically in 5402. And you'll sit with injured workers and they will get it on the record, if only on the record between your ears. They'll get it on the record that they reported the injury. And so it's important for you to understand what actually constitutes proper reporting or any reporting of the injury. So we spent some time talking about that because reporting of the injury is important. There's a 30-day statute of limitations for reporting both specific and cumulative trauma injury claims. For specific injury claims, there's a 1-year statute of limitation for the filing of the claim, for the filing of an injury claim. After the injury has been reported, there's a 1-year statute. And for cumulative trauma injury claims, there's an unlimited statute of limitations. There is no statute of limitation for the filing of the claim. In fact, we're going to review some cases today that involve the filing of the injury claim, weeks, months, years, and I even have some cases on my desk where the initial filing of the injury claim form comes a decade and decades after the last date of exposure to the cumulative trauma. So there is no statute of limitations. And that's why we get so many of these cases, because there's no statute of limitations. Okay? I have a case on my desk that I'm working on right now in 2024 where the allegation for cumulative trauma injury dates back to the last date of employment in 2016. So that was 8 years ago. The last date of exposure to cumulative trauma was over 8 years ago, and the claim is just now being filed. Isn't that fascinating? So there is no statute of limitations, and that's why we get so many of these cases, because they're filed long after the exposure. You could say that they sort of have a tail. These claims have a many-year, multi-year tail to them. And then in our last session, we spent the entire session talking about what is going to make up the bulk, at least 50% of all of your evaluations will be comprised of the post-employment cumulative trauma injury claim. And for the most part, most of these cases come to you as denied claims. The claims administrator has saw fit to exercise the affirmative defense under Labor Code Section 3610, the post-termination defense, and these claims come to us as denied claims for our AOE COE determination. Our determination either for industrial injury or against industrial injury. And you're going to get a throng of these. So it's important for you to be able to, number one, to be able to recognize this case when this case comes across your desk. In other words, in order to be able to recognize what it is that you're dealing with. If you can identify that you're dealing with a post-employment cumulative trauma injury claim, then you know exactly how to handle it. You know exactly what questions to ask the injured worker in the face-to-face evaluation. You understand exactly how to comport yourself in the face-to-face evaluation and the physical exam. You know exactly what your directive is as issued to you by the parties. And you know exactly then how to quickly and accurately get this report done and get it off your desk in a way that it's accurate and in a way that it resolves the disputed issue of the parties. Okay, so these cases have an exact handling. We talked about that in our last session, and we'll talk more about that as we continue throughout the remainder of our program. So that brings us to today's session. In today's session, I want to go over 3 case examples, 3 interesting cases that deal with some of these disputed issues that we've been talking about. Disputes over the date of injury, disputes over reporting the injury, disputes over the post-termination defense in post-employment cumulative trauma injury claims. And so the purpose of today's discussion is to help make real for you some of these ideas and concepts that we've discussed so far, so that you can have the realization. And realization is defined as something becomes real to you. When something becomes real to you, we say you have a realization, so that you can have the aha moment realization of the big picture that's operative in not only these cases that we're going to talk about today, but also in the cases that cross your desk for your opinions and your determinations. So I have a fascinating program today that's going to tie together some of these seemingly loose ends and bring the big picture full circle for you. So with that as our introduction, and I'm very excited today, let's begin session number 4 of our new program entitled Update on Trends in the Cumulative Trauma Injury Claim. Okay, so let's begin and let's remind ourselves of some important principles that are operative in these post-employment cumulative trauma injury claims. So first of all, remember Labor Code Section 3600 is specifically, so 3600 is described as the conditions of compensation liability. And then sections 4 through 10 of Labor Code section 3600 constitute what are known as the affirmative defenses. And affirmative defense number 10 has to deal with post-termination filing of claims. Well, section D of 3600 subsection 10 says that no compensation for these claims shall be paid unless the date of injury of a cumulative trauma injury, the date of injury for that injury is after the date of notice of termination or layoff. So these types of claims that are filed post-termination by law, and the law is 3600 section 10, do not fly. They're barred, they're blocked, they're banned, they're prohibited, they're denied, they're negated, okay, by law, except in those situations where an actual injury actually did occur, but for whatever reason, it either did not manifest or it did not develop, or the injured worker did not develop symptoms or have disability until long after the notice of termination or layoff. So for example, imagine a fire captain who has a 35-year career and has a happy and otherwise healthy retirement, gets the gold watch and all that stuff, and then 2 years later develops a cough, and that cough is traced back to the exposure to smoke and fumes over the course of his career as a fire captain. Well, in these situations, the date of injury is long after the date of notice of termination or layoff or retirement or quitting or resignation, etc. So these persons are protected under this exception, which is exception D. And it's this exception D that brings so many of these evaluations to us for our determination. So section D is largely dependent on the date of injury. The specific language of this section says that the date of injury, as specified in section 5412, which we'll go over in just a minute, is subsequent, meaning after the date of notice of termination or layoff. So this exception is heavily dependent on what is the date of injury. If the date of injury can be established to be after the notice of termination or layoff, then the claim can fly. If the date of injury is established to be before the date of notice of termination or layoff, then the claim is blocked by the general provisions of 3600 section 10. Okay? So it's heavily dependent on the date of injury. So the date of injury, as we learned in our last session, is described in Labor Code section 5412. 5412 says that the date of injury is that date upon which the employee first suffered disability therefrom, and, so it's a two-part requirement, and either knew or in the exercise of reasonable diligence should have known that such disability was caused by his or her present or prior employment. Now, let's just take a look at this language, and this is the exact language from 5412. As we look through the language of this paragraph, let's ask ourselves, in this paragraph, what are some of the issues that can be disputed? Where are some of the disputable issues found within this paragraph? Well, how about this? How about the date? There's your first source of great dispute over these types of claims. How about the date that the employee first suffered disability? This whole thing is a subject of great and many disputes, and many arguments arise over the date of first disability. And you can imagine some of the parties saying that no, the disability was on such and such a date, and another party, another insurer perhaps, looking to escape liability for this claim says, no, the date of first disability was not during our period of coverage for this claim. It was during your period of coverage for the claim. And this is an area of great dispute. What's the next area of great dispute? How about the next one? And either knew. Can you imagine an injured worker saying, I never knew that the disability, my cough, my skin cancer, my bad lower back, I never knew that that was in any way due to my present or prior employment. I didn't know that. And then the employer comes back and says, oh, come on, within reasonable diligence, any person should have known that that cough, that skin cancer, that bad medial epicondylitis condition, you should have known. You should have known that. And the injured worker comes back and says, nope, I'm just a layperson. I'm not medically trained. I didn't know. And you can see that this is an area of great dispute, okay? And then how about the next one? That the disability was caused. And you can see one party arguing that no, the disability wasn't caused by the employment, and the injured worker and the applicant attorney arguing, oh, yes, it was. Oh, yes, it was. Well, the defense attorney comes back and says, well, that wasn't due to your present employment or your prior employment even. It was due to the employment even before that. And these are areas of great dispute, multiple disputes. And thank goodness for all these disputes, because it's these disputes that bring these cases to us for our medical determinations. We'll talk about our role in these particular disputes. So for the cases that I want to share with you today, we're going to focus on some of these disputable issues. And the first one I want to focus on has to deal with the disability. So let's review the language. The language says the date upon which the employee first suffered disability. So it might be important for us to understand in establishing this date of injury, this important hallmark milestone date, the date of injury. It's important for us to understand what is meant by the term disability. How, in this context, is disability defined? What constitutes the disability? Is it one single factor? Is it multiple factors? How do we define disability? How do we know that the employee is suffering disability? So we're going to focus our attention on this particular concept of the disability. So far, we've seen this term disability described in at least two labor codes. It's described in 5412 with regards to the date of injury. The date of injury is the date upon which the employee first suffered disability and knew, or in the exercise of reasonable diligence should have known, that such disability was caused by his or her present or prior employment. So disability is described in 5402. It's also described in Labor Code 3208.1 in the definition of injury, as injuries defined in California workers' compensation. So recall that an injury is when the employee or injured worker has a condition, and that condition either causes disability, and there's our second exposure to the term disability. It either causes disability and or a need for medical treatment. So what actually constitutes, in case law that is, what constitutes the disability? So let's talk about that in today's discussion. Is the need for medical treatment in and of itself, does that constitute the disability? Or is something more required in addition to the need for medical treatment? We have a case that discusses this very issue. How about work restrictions? Does the presence of work restrictions, in other words, modified work duty, does that constitute disability? You know, sometimes we refer to an injured worker who is working under modified work duties. We say that that injured worker is under TPD, temporary partial disability. So for the purposes of Labor Code Section 5412, establishing the date of injury, is that the modified work duty, the work restrictions, is that sufficient to constitute the disability as described in 5412? Well, we're going to see. What about the need for orthopedic devices? Does orthopedic devices, prescribed orthopedic devices such as a cane, such as a sling, such as braces, and other supports such as orthotics, etc., does the prescription of these orthopedic devices by a primary treating physician, does that constitute disability? Can a primary care physician prescribe these orthopedic devices? And is that in itself sufficient to constitute the disability? It's very interesting questions. Or is it simply compensable disability that constitutes the disability under Section 5412? So, for example, is it temporary total disability that has accompanying wage loss? In other words, there's compensable disability. Is that what's meant by the term disability in establishing the date of injury? Or can permanent disability establish the date of injury by constituting the disability? Permanent disability with diminished future earning capacity. It's a very interesting concept because imagine this. Imagine an injured worker comes to you 2 years after their last date of exposure, after their last date of employment, and you see them for your evaluation the very first time with yet a date of injury as yet not established. Many times these injured workers come to us and the date of injury for administrative purposes has not yet been established. Can your evaluation establish the date of injury? If you were to evaluate the injured worker to declare them permanent and stationary on the day that you did your evaluation and you provide a permanent impairment rating and there is permanent disability on that day, could that date, the date of your evaluation, establish the date of injury under Section 5412? Very interesting questions. And all of these questions, I pose them to you this way because all of these questions are going to translate over into your face-to-face evaluations. You're going to see these scenarios if you'll just sharpen your awareness to the presence of these scenarios. You'll see them as being operative in your evaluation. And when you spot these scenarios, you'll know exactly what you're dealing with and you'll know exactly what to do. So let's explore what case law has to say about what actually constitutes the disability. Okay, so the first case that I want to share with you is the Wagner versus WCAB case. And each of these three cases that I'm going to share with you today are all historic and classic cases that describe the resolution of some of these difficult disputes historically. And this particular case, Wagner versus WCAB, this is a case that was published in 2000. So this was even before the adoption of the AMA guides and the new permanent disability rating schedule that we're now using. This was under the 1997 permanent disability rating schedule, but even so, the disputed issues in the Wagner versus WCAB case are independent of the permanent disability rating schedule. The disputed issues that we're going to talk about that are relevant to us have to deal with the date of injury for cumulative trauma injury claims. So in the Wagner case, Wagner, the worker, alleged a cumulative trauma injury from 10/28/1990 to 10/28/1991. The injury was alleged to be to multiple body parts. So as we know, liability for cumulative trauma injuries is assumed by the insurer over the last year of the cumulative trauma exposure. Okay, so this was the last year of the cumulative trauma exposure. Well, you can imagine that the period of cumulative trauma exposure can be an issue in dispute. So for example, in this case, the stakes were extremely high because Wagner qualified for temporary total disability payments, qualified for medical treatment payments, and also qualified for a permanent disability award, which was an unapportioned award based on the opinion of the Qualified Medical Evaluator and as approved by the judge. So there was an unapportioned permanent disability award. So the stakes were extremely high because the monies were quite high. Well, throughout the last few years, this particular employer had multiple insurers. So for example, insurer A was responsible during the period of time between 3/1/89 and 11/23/89. So you can imagine that insurer B and insurer C are going to try to confirm or prove that the last cumulative trauma exposure was during this period of time when this insurer was liable. Well, there was a second insurer that had the policy between 11/23/89 and 11/23/90. So you can imagine insurer A and insurer C both pointing the fingers to this particular time period as the period of the last year of cumulative trauma exposure. And then finally, insurer C was on the job between 11/23/90 and 11/23/91. And it's insurer C that appears to have the liability for this particular period of time. 10/28/90. 10/28/90 falls slightly before this period, but overlaps to 10/28/91 into this period here. So it appears that insurer C has the bulk of the liability, but at least there is some overlap from 10/28/90, which was before insurer C was on the job and was during the period of time that insurer B was on the job. So somehow, and in some percentage proportion, there is some overlap in liability between these two employers. So I think you can pick it up from here. I think you can imagine that each of these insurers is going to try and drop the hot potato into the lap of the other and try to establish that the majority of the period of exposure was on the other party, okay? So I can see, I'm sure you can see how these disputes could unfold. Well, as we're going to see in the case, the dispute arose as to whether the date of injury under Labor Code Section 5412, remember, which is the occurrence of two things, disability and the knowledge that the disability was due to the present or prior employment, whether that date of injury was 5/28/91 versus 8/26/91, thereby shifting the various percentage of the liability period to one or the other of the insurers. So, of course, insurer C wanted to establish 5/28/91 as the date of injury, thereby pushing the liability more, the last 1 year period of liability more toward insurer B, and insurer B wanted to have 8/26/91 established as the date of injury, thereby shifting the last year of cumulative exposure more towards insurer C. And it might seem to be to you only a 3-year difference, a 3-month difference that might seem inconsequential to you, but this has to deal with large dollars, considering all of these temporary disability benefits, medical treatment benefits, and unapportioned permanent disability benefits. It turns out to be substantial dollars, and so these arguments over days, weeks, and even just a few months were at least important to the players. Okay, so let's take a look at some of the details of this case. Okay, so here's the case here. This is Wagner versus the WCAB, Workers' Compensation Appeals Board versus Sandra Wagner. So remember that we said that there's 3 insurers involved here. So it says here the defendant was insured from 3/1/89 through 11/23/89 by Golden Eagle, the next period of time by Fairmont, and by the next period of time by CIIC. And it's CIIC that's fearing that they're going to be holding the bag for the bulk of the liability for this cumulative trauma injury. So CIIC alleged that the applicant sustained CT due to her employment from 189 to 989, 189 to 989, thereby putting it, let's get a highlighter here, thereby putting it within the liability period right here of the first insurer, which is Golden Eagle Insurance. CIIC alleged that the applicant sustained CT due to her employment from 189 to 989 and a specific injury on 4/5/89. 4-5 falls within this time period during which Golden Eagle Insurance was the insurer. Now, we don't know this from the case. We don't know where CIIC gets their data to support a CT and a specific injury. We're not told that in this case, but they had reason to believe, and they had support for their argument, that they were not responsible at all for liability for this particular claim, and that was part of their argument. Well, by review of the medical record, we learned that the applicant began experiencing upper extremity symptoms in 591. Now, 591 puts that squarely here within the liability period of CIIC, directly in the center of this liability period. But remember, liability is spread over the last 1 year of exposure, depending upon when the date of injury is set. So if the date of injury is set at 5/1/91, right in the middle here of this time period, the 1 year exposure would go backwards from 591 up into this exposure period of this insurer, Fairmont Insurance. Okay? So that's what CIIC is hoping, is that the exposure period will go largely back in time to the period in time when there was another insurer to be responsible for the liability. So let's follow this case. So she began experiencing symptoms in 591, for which she received treatment at the hospital emergency room. So there was a hospital emergency room in May of 91, and then on an industrial basis, she began treating with Dr. McSweeney on August 26, 91. So if August 26, 91 is established as the date of injury, you can see that the backwards liability period, August 26, would extend from about here. Let's get a different color. From about here, only partly way back into the time during which Fairmont was the insurer. So only a small sharing of the liability with Fairmont, and most of the liability falling on CIIC. So Dr. McSweeney started some treatment. He diagnosed her with a bunch of conditions. He said that she could return to full duty with no restrictions, but he prescribed the wearing of braces for both wrists while at work. All right, so let's be clear. In May of 91, the injured worker had symptoms. She required medical treatment. Remember, an injury is defined as disability and or a need for medical treatment. So the need for medical treatment was established here in 591. And then more treatment continued 8/26/91, but it was 8/26/91 that she was released to full duty, but she was prescribed the wearing of braces. Okay? So there's some concern over this time period here and the 1 year exposure. So after hearing in this matter, the work comp judge found that applicant sustained an industrial CT injury to her upper extremities during her employment in 1991 and 1992. He found that the date of injury was 8/26/91, which was when the applicant began treating with Dr. McSweeney. Very interesting, because we know that she began treating even earlier. She began treating in May. But here, the workers' compensation judge felt that this treatment with Dr. McSweeney established the date of injury. Okay? The workers' comp judge also found that applicant did not sustain a CT injury due to her employment in 89 or during any period of time in 89, as was initially alleged up here by CIIC. So the first insurer, which is Golden Eagle is now off the hook, and the dispute falls between Fairmont Insurance and CIIC. Okay, so let's continue. With regards to the applicant's date of injury, the workers' comp judge pointed out that the first evidence indicating that applicant had a disability due to her CT was when she was seen by Dr. McSweeney on August 26, 91, and he reported that she should wear wrist braces. So very interesting. Here we see on 8/26/91 the confluence of the disability and the knowledge that the disability was caused by the prior or present work duties. Now actually this injured worker Wagner learned in May 91 that her symptoms were due to work. So it was in May 91 that she had the knowledge. So the first box is checked in establishing the date of injury. That is the knowledge. The first box was checked May 91. But the second box, the disability, was not established until later on 8/26/91. So 8/26/91 became the date when both of those boxes collided. The knowledge of the disability and the actual disability collided on 8/26/91, and therefore CIIC, the insurer CIIC, was largely and mostly responsible for the liability, with only a small piece or a small overlap going to the second insurer, which was Fairmont Insurance. Okay, so let's just read the conclusion of the case. In this case, the employee was told by the doctor in May that her problems were work-related. So that's when she got the knowledge. However, the workers' compensation judge found she had not suffered a disability at that time. Petitioner apparently relies on Mrs. Wagner's testimony that she reported a workers' compensation claim and self-limited her work in May. Okay, so this is when CIIC thinks the date of injury should be established, because this is when the injured worker Wagner, she reported the claim in May and she self-limited her work in May. And CIIC contended that her self-limiting her work constituted the disability. However, CIIC provided no authority that simply reporting a claim or self-limiting your work constitutes a disability. So let's go back to our question. We asked, do work restrictions and reporting a claim constitute the disability? Well, according to this case, the answer to that is no. CIIC also relied on the employee having missed work in May because testimony, they relied on the employee having missed work in May. Apparently, there was some evidence that Ms. Wagner missed a day of work in May, and CIIC contended that this missed one day of work constituted the disability. But because the testimony regarding the worker's time off was equivocal, and the employer failed to substantiate any such time off by either medical or personnel records, the workers' compensation judge concluded that the worker had not suffered disability in May, much to the consternation of CIIC. And the WCAB concluded that the workers' compensation's conclusion is reasonable. Okay? Okay, so let's review the arguments in this case, Wagner versus the WCAB. So CIIC, the insurer during the ultimate final period of liability, they argued for a May 1st, 89 date of injury in order to offset some of these huge costs associated with this claim. They argued that the injured worker Wagner had the first component necessary to establish the date of injury, and that was knowledge. And they alleged, or they argued, that Wagner had knowledge in May of 89 when she went to the emergency room and she was told by the doctor there that her problems were work-related, that she had knowledge when she herself reported a workers' compensation claim, that she had knowledge when she herself reported the injury to her employer. So knowledge was undisputed, actually. Knowledge, the date of knowledge was found to be in May of 1989, but the crux hinged on the disability. And CIIC insurer argued that May 89 was also the date of first disability, because that was when Wagner stopped lifting heavy items at work. In other words, she self-imposed work restrictions on herself. This is when she told her employee that she was not lifting heavy items and that the medical record established that she missed at least one day of work. So all of these factors seem to be a slam dunk in favor of CIIC at the time, but the workers' compensation judge saw things differently, and the workers' compensation judge concluded for an August 26, 91 date of injury on the basis that this was when she returned to full work duty, but she returned with braces for both wrists. The braces are the orthopedic devices, and it was the opinion of the workers' compensation judge that was upheld by the WCAB, by the way. 2 out of 3 commissioners ruled in favor of the workers' compensation judge that it was the braces that established the disability and not necessarily just the self-limiting of the work, the self-imposed work restrictions, the reporting the injury to the employer, and missing one day off work. Now, it might have been a different story if the employer had been a little bit more helpful in corroborating and documenting this one day off of work. But the employer either was unable to document this or failed to participate or cooperate, but whatever. And the one day of missed work was not substantiated. But it was the braces that established the disability. So in this case, the Wagner case, the disability was established by the need, the medical need for orthopedic devices. Isn't that interesting? Well, let's take a look at another case and see how these issues relate to the date of injury in a completely different type of case. So far, we've seen this term disability described in at least 2 labor codes. It's described in 5412 with regards to the date of injury. The date of injury is the date upon which the employee first suffered disability and knew, or in the exercise of reasonable diligence should have known, that such disability was caused by his or her present or prior employment. So disability is described in 5402. It's also described in Labor Code 3208.1 in the definition of injury, as injuries defined in California workers' compensation. So recall that an injury is when the employee or injured worker has a condition, and that condition either causes disability, and there's our second exposure to the term disability. It either causes disability and or a need for medical treatment. So what actually constitutes, in case law that is, what constitutes the disability? So let's talk about that in today's discussion. Is the need for medical treatment in and of itself, does that constitute the disability? Or is something more required in addition to the need for medical treatment? We have a case that discusses this very issue. How about work restrictions? Does the presence of work restrictions, in other words, modified work duty, does that constitute disability? You know, sometimes we refer to an injured worker who is working under modified work duties. We say that that injured worker is under TPD, temporary partial disability. So for the purposes of Labor Code Section 5412, establishing the date of injury, is that the modified work duty, the work restrictions, is that sufficient to constitute the disability as described in 5412? Well, we're going to see. What about the need for orthopedic devices? Does orthopedic devices, prescribed orthopedic devices such as a cane, such as a sling, such as braces, and other supports such as orthotics, etc., does the prescription of these orthopedic devices by a primary treating physician, does that constitute disability? Can a primary care physician prescribe these orthopedic devices? And is that in itself sufficient to constitute the disability? It's very interesting questions. Or is it simply compensable disability that constitutes the disability under Section 5412? So, for example, is it temporary total disability that has accompanying wage loss? In other words, there's compensable disability. Is that what's meant by the term disability in establishing the date of injury, or can permanent disability establish the date of injury by constituting the disability? Permanent disability with diminished future earning capacity. It's a very interesting concept, because imagine this. Imagine an injured worker comes to you 2 years after their last date of exposure, after their last date of employment, and you see them for your evaluation the very first time, with yet a date of injury as yet not established. Many times these injured workers come to us and the date of injury for administrative purposes has not yet been established. Can your evaluation establish the date of injury? If you were to evaluate the injured worker to declare them permanent and stationary on the day that you did your evaluation, and you provide a permanent impairment rating and there is permanent disability on that day, could that date, the date of your evaluation, establish the date of injury under Section 5412? Very interesting questions. And all of these questions, I pose them to you this way because all of these questions are going to translate over into your face-to-face evaluations. You're going to see these scenarios. If you'll just sharpen your awareness to the presence of these scenarios, you'll see them as being operative in your evaluation. And when you spot these scenarios, you'll know exactly what you're dealing with, and you'll know exactly what to do. So let's explore what case law has to say about what actually constitutes the disability. Okay, now in the Wright case, Wright filed a cumulative trauma injury over an 8-year period of time from 1989 to 1997. Now, we see these cases all the time with these extended cumulative trauma periods. Sometimes we get these cases, and I have a couple of them on my desk, where the applicant attorney is alleging cumulative trauma over what they refer to in quotation marks as over the entire career or over the entire working career with ABC employer. Well, this may be an example of such an allegation. In any event, this cumulative trauma period spans a period of 8 years. And you can imagine that during this period of time, the employer could have 1, 2, 3, 4, multiple insurers. Well, in this case, there were 2 insurers. Travelers was responsible for the insurance between 1989 and 1995, the bulk of the cumulative trauma period. And then at the very end, for a short period of time between 795 and 197, Cigna took the responsibility and the liability during that time period. And remember, liability for cumulative trauma injury claims falls upon the insurer who's providing the insurance over the last year of cumulative trauma exposure. So in that case, it's clear that Cigna is the insurer over the last year of the cumulative trauma period. This is where establishing the date of injury for a cumulative trauma injury claim becomes so important, because each of these insurers want to point the finger at the other insurer for the liability. So therefore, establishing the date of injury is critical. So for example, if the date of injury can be established before 6/30/95, then the 1-year period of cumulative trauma exposure would backdate into 94, and travelers would bear the entirety of the liability for that injury. Whereas if the date of injury is established after 7/1/95, or even let's say 7/1/96, then the 1-year period of liability would extend back into here 7/95, and Cigna would be 100% liable for the insurance for that injury. So in this case, where the cumulative trauma period spans the liability periods for 2 different insurance carriers, each of those insurance carriers are going to want to establish the date of injury on the other's liability period. And I'll explain how this applies to us as QMEs here as we go in just a couple minutes. So of course, there was a dispute over the date of injury. Well, very fascinatingly, the arbiter in this case found 2 cumulative trauma injuries. and I'll explain the arbiter's reasoning for concluding that there were not just one cumulative trauma injury between 10/30/89 and 1/9/97, but actually that the cumulative trauma periods were separated, and there was 2 cumulative trauma periods versus just 1 cumulative trauma period. So in this case, we might see where each insurance carrier is pointing the finger at the other. In this case, each insurance carrier gets to bite off a piece of the liability for not just 1, but 2 cumulative trauma injuries. So the date of injuries was for 10/30/89 through 5/95. So that is 100% under the obligation of Travelers. And then the second cumulative trauma period was from 5/95 to 1/1/97, a period covered by both Cigna and Travelers. So there was some sharing of liability for the second date of injury, and it was Travelers that bore the burden 100% for the first date of injury. And just as a side note about this case, the arbiter found that the majority of the damage of the injury was over this liability period. So really, Travelers ended up holding the bulk of the liability on this case, and of course, they demanded a reconsideration of this determination. Okay, so let's take a look at some of the facts of this case, and then we'll look at the actual case itself. So recall that Wright filed a cumulative trauma injury over an 8-year period of cumulative trauma exposure. Well, late into the cumulative trauma exposure, as Wright was nearing his conclusion of his tenure with this particular company, and this happens so typically with a lot of injured workers, it's later on that they develop these problems. So in May of 1995, Wright went to the doctor with symptoms, with limitations to activities of daily living, with a problem with his hip. And the doctor told him, after diagnosing the hip condition, the doctor told him that his hip problems were work-related. So in 5/95, May of 1995, Wright gained the knowledge that his problems were work-related. So the first component of the date of injury under Labor Code 5412 is now established. Okay, and this is what one of the insurance companies is going to rely on in establishing the date of injury, is that Wright had knowledge during the liability period of Travelers insurance. Okay, the doctor recommended hip surgery. So the recommendation for hip surgery serves as a need for medical treatment. The doctor described a need for medical treatment, okay? And the need for medical treatment, as we know, is one of the component parts of the definition for injury, whether we're talking about a specific injury claim or a cumulative trauma injury claim. The need for medical treatment is what establishes an injury. So the doctor clearly is describing that there's an injury, he's recommending medical treatment, and he's providing Mr. Wright knowledge of industrial causation as early as May 1995. However, for reasons that aren't explained in the case, the surgery was deferred. So there was no medical treatment delivered, and the surgery was deferred. Mr. Wright continued to work until the hip surgery on January 9th, 1997. So after Wright went to the doctor, there was no period of total temporary disability. There was no compensable disability. Typically, we think of compensable disability as necessary to establish disability under Labor Code 5412 in establishing the date of injury for a cumulative trauma injury claim. But he had no temporary disability. He continued to working. So this is where Travelers, who's now saddled with at least knowledge was gained during the liability period of Travelers. This is where Travelers is going to say, but no, we're not liable, because during this period of time, Mr. Wright did not suffer any disability, and then therefore the second box is not checked. The second box for establishing the date of injury is not checked. There was no disability, and therefore there is no date of injury during our period of liability. Well, the arbiter in this case actually found 2 cumulative trauma periods. And this is very fascinating. I wonder if you, as the qualified medical evaluator, would ever have the moxie to make this particular determination in any of your cases. And let's break it down how this was established. The arbiter found 1 cumulative trauma period from the beginning of the employment all the way through to 6 years later when Mr. Wright first had his first need for medical treatment. And this cumulative trauma period is based on the finding of a cumulative trauma injury through the testimony of the doctor who described a need for medical treatment. The need for medical treatment is what solidified the finding of an injury. And so there was an injury found, and the cumulative period was 1089 through 995. This finding of an injury was not based on disability, was not based on compensable disability, it was not based on missed time from work. It was solely based on the need for new medical treatment, effective May of 1995. And then through May of 1995, through the date of the hip surgery, Mr. Wright continued to work until January 9, 1997, when he actually underwent the hip surgery. So the actual hip surgery procedure served as the second and new need for medical treatment, thus establishing a second and new cumulative trauma injury, and thus establishing a second and new cumulative trauma period, now bleeding over into the liability period of Cigna, the second insurance carrier. So fascinatingly, in this case, similar to our last case, compensable disability in the form of either temporary disability or permanent disability was not required in order to establish the disability. In this case, the disability, okay, we already had knowledge. We had knowledge. Now all we need is disability, and for those two to intersect in order to qualify for a date of injury under Labor Code 5412, the compensable disability was not required. All that was required was a need for medical treatment, a need for medical treatment. Now, in our last case, the Wagner case, the need for medical treatment, surprisingly, was not sufficient to establish the disability. It was the prescription of the wrist braces that established the disability. So we're seeing some mixed messages come down through the courts, and I have a third mixed message to share with you in our next case. But let's just take a look at some of the facts of the actual case so we can wrap our head around some of these interesting concepts. Okay, so here's the case. This is Wright versus the WCAB. And just a couple facts about this case. In this case, the arbiter found 2 cumulative trauma injuries. The first was from the beginning of the work relationship through 595, when Mr. Wright first got his opinion from Dr. Hunt that he needed surgery and that the surgery was related to the workplace duties. The arbiter also found a second period of CT from May of 95 through the applicant's last day of work in 1997. And in both cases, the arbiter's finding with regard to the periods of CT was based on applicant's need for medical treatment rather than on whether the applicant sustained disability or missed work during his or her employment. And these are what we typically rely on in terms of establishing disability. It's usually compensable disability that establishes the disability. So in this case, there was no temporary disability. There was no opinion for permanent disability during this cumulative trauma period. So all the arbiter relied upon was the need for medical treatment times 2. Two needs for medical treatment clearly established in the mind of the arbiter two separate and distinct cumulative trauma periods. So, of course, travelers looking at holding the bag for liability on this determination, they filed a petition for reconsideration. Travelers contended that it was error to find two separate dates of cumulative trauma injury because, and they lobbied for one single period of cumulative trauma, hoping to shift the liability to the other carrier, Cigna. But they said it was an error because applicant never missed time from work or sustained disability in 1995, as is typically required by Labor Code Section 5412. And further, they contended that it was error to base the findings of the dates of injury on simply the need for medical treatment, which, without permanent disability or temporary disability, is not sufficient to establish a date of injury. And so the parties went back and forth with travelers looking for some relief on this determination. And the arbiter justified his or her position in establishing two dates of injury by relying on the definition of injury as described in Labor Code Section 3208. And we've gone over this in prior sessions. The definition of a cumulative trauma injury claim is that the injury occurs as repetitive mentally or physically traumatic activities extending over a period of time, the combined effect of which causes any disability, which was not established in this case, or a need for medical treatment. So in this case, and this is so fascinating, the arbiter found two separate and distinct recommendations for medical treatment and relied upon those two separate and distinct recommendations for medical treatment as establishing not just one, but two periods of cumulative trauma exposure. And we can do this also as qualified medical evaluators ourselves. We can look to the medical records and scan the medical records for these various recommendations for medical treatment, which may, in certain circumstances, justify separate and distinct cumulative trauma periods. So let's just get to the conclusion and we'll move on. Travelers, of course, was not happy. They filed a petition for writ of review, essentially contending that the need for medical treatment alone is not sufficient to establish a date of injury in a cumulative trauma case pursuant to Labor Code 5412, and the writ was denied and the case was closed, and that was it. And Travelers was left holding the bulk of the bag, which they were hoping to shift to the second insurer. Isn't that very interesting? And there's no explanation as to how, in this particular case, the need for medical treatment establishes the disability, but the arbiter simply concluded, and the writ was denied by the WCAB with no further explanation. But the conclusion is that in certain circumstances, the need for medical treatment alone, even in the absence of temporary or permanent disability, can be sufficient to establish the date of injury. Okay, so in establishing the date of injury under Labor Code Section 5412, we need two things. We need knowledge and we need disability. And in the Wagner case, it was the need for orthopedic devices that established the disability in establishing the date of injury. In the Wright case, it was the need for medical treatment that established the disability and established the date of injury. We've yet to see a case yet where work restrictions alone can establish the disability, but there are those cases. And then next, we have a case known as the Rodarty case, where not orthopedic devices, not a need for medical treatment, but compensable disability is required to establish the disability, which is required to establish the date of injury. And in a unique twist, we're going to see that in the Rodarty case, the compensable disability turns out actually to be not temporary time away from work with wage loss, but actual permanent disability established by the Qualified Medical Evaluator in a fascinating case which has application for us with a lot of these post-employment cumulative trauma injury cases that we encounter. So let's explore the Rodarty case. Okay, so let's take a look at the Rodarty case and see if we can confuse ourselves even further or whether this case adds some clarity to our understanding. So in the Rodarty case, Rodarty, which was a female, Rodarty is a female, Rodarty worked from 1995 through 1998, a short 3-year period of time. And interestingly, over this period of time, there were 2 insurers, each seeking to point the finger of liability at the other, depending upon where the date of injury can be established. So in October of 1997, during the liability period of California Insurance Guarantee, Ms. Rodarty received medical care consisting of anti-inflammatory medications. She received a wrist splint. So there's the orthopedic devices, which established the date of injury, which established the disability. Okay, established the disability in the Wagner case. And she received physical therapy treatment. So there's the medical treatment, which established the disability in the Wright case. And she returned to modified work duties, which State Fund is going to argue constitutes disability. Now, it's interesting because modified work duties are work duties that are accommodated by the employer. If the employer cannot accommodate the work duties, the employee goes home on total temporary disability, which certainly constitutes compensable disability and would certainly unequivocally constitute disability for the purposes of Labor Code Section 5412. So State Fund is going to argue that these modified work duties contributed or constituted solely the disability. But if not constituted solely, then in combination with the need for medical treatment, with the need for orthopedic devices, similar to the prior cases that we discussed. So State Fund argued for the liability period through 96 and 97 prior to their liability period in 1998 over a short 5-month period of time. Okay, so that's what State Fund argued. So Ms. Rodarty continued working until almost a year later in 1998 when she was terminated. Okay, when she was found to be working on modified work duties and not capable of doing the duties for which she was hired, she was terminated. She had surgery, and she was found permanent and stationary by the agreed medical evaluator on May of 2000. And the agreed medical evaluator, much to the consternation of State Compensation Insurance Fund, opined for one single CT period, thus bringing in both insurers. Okay, so let's take a look at the Rodarty case. Here it is, State Compensation Insurance Fund versus the WCAB, also known as the Monica Rodarty case. And let's go through it. So Rodarty obtained medical care consisting of anti-inflammatory medicines, a wrist splint, and physical therapy beginning in 1997. She filed a claim for benefits also in October 1997 during the period of insurance by SIGA entirely outside of the liability period of State Compensation Insurance Fund. So State Compensation Insurance Fund is happy with this these historic facts because it points to a date of injury prior to their period of liability coverage. Well, Ms. Rodarty underwent surgery. She was terminated on August 7, 1998. This is now into the period of liability of State Compensation Insurance Fund. She then underwent surgery. She saw the agreed medical evaluator on May 31st, 2000. And AME found a single continuous trauma during the entire employment period spanning the liability periods of both insurers, to which State Compensation Insurance Fund is now going to be upset because the facts seem to suggest that 1997 was the proper date of injury and the proper cumulative trauma exposure period. Well, because the agreed medical evaluator found a single continuous trauma period extending through August 1998, the workers' compensation judge found the date of injury to be August 7, 1997 to August 7, 1998, the year preceding her termination. Therefore, the first insurance company was dismissed and State Fund was ordered to pay the entire award. The judge ruled that the filing of the claim in 1997 established the requisite knowledge for the purposes of Labor Code Section 5412. The only thing left to establish the date of injury was the disability. So State Fund contended that both the knowledge and the disability began in 1997, but the finding is that even though the knowledge was established in 1997, the disability was not established until later, when it was established by the medical evaluator. And this is important for us in our medical evaluations that involve these exact types of cases. So State Fund petitioned for reconsideration, contending that the date of injury was correct. State Fund pointed out that Rodarte had filed a claim form in 1997 when she received splints and was placed on modified duty. So State Fund asserts that in 1997, both disability and knowledge, the two components required to establish the date of injury, had indeed coincided, and then therefore the correct date of injury should be 1996 to 1997, therefore alleviating and relieving them of liability for any liability whatsoever, that the entire period preceded State Fund's coverage and falls wholly during SIGA's coverage. So fascinating. So the board disagreed with this finding, holding that the term disability, now here in its rigid definition and rigid application, means compensable temporary disability, that is, lost time from work. And they cited a couple of cases that supported that conclusion. On that basis, the board concluded that Rodarte was not temporarily disabled until after she left employment on August 7, 1998, because Rodarte contended that had she not been terminated, she would have continued working. She was terminated from her employer while she was on modified duties. Okay, so let's get to the conclusions of the Rodarte case. So in Rodarte, the judge opined for the cumulative trauma period to be the entire working career between 1997. The cumulative trauma period was found to be over the entire working career, and therefore liability for the cumulative trauma injury is assigned to the insurer during the last year of cumulative trauma exposure. So the workers' compensation judge opined that the period of cumulative trauma exposure liability period was 8/7/97 through 1998, thereby leaving State Compensation Insurance Fund with the liability. Well, was this the correct date of injury? According to the Wright case and the Wagner case that we just reviewed, it would seem that this would not be an accurate date of injury, that 10/97 would have been the accurate date of injury when both knowledge and apparent disability, based on the need for wrist braces and based on the need for modified work, it would seem that disability was established in 10/97, but the actual date of injury was found to be 8/9/98, which was the last date of employment of Ms. Rodarte. So the WCAB explained their reasoning on this by defining what they defined to be disability. According to the Rodarty case, disability refers specifically and narrowly to compensable disability. Now, we have two forms of compensable disability. We have temporary disability and we have permanent disability. Now, temporary disability requires, in order to qualify as disability for establishing the date of injury, requires lost time from work with wage loss. Now, Rodarty never did suffer temporary disability during the employment period. She never had compensable time off work. She had modified work duties, but that's not the same as compensable time off work. So there was no temporary disability established. And how many times do we get these cases ourselves, especially in the post-employment cumulative trauma injury claim, which is exactly what Rodarty's claim was. Even though she filed it prior to termination, it wasn't until after her termination that she was declared permanent and stationary. So we get these types of cases all the time where there is no documented temporary disability, but the WCAB ruled that Rodarty was temporarily disabled after she left the employment. That became the wage loss period. And specifically with regards to Rodarty, she said that she would have continued working. She wanted to continue working, but she was terminated because she was on modified work duties and she could not do the duties for which she was hired. And how many times do we hear this scenario? So she became temporarily disabled until after she left the employment, and then she was found to have permanent disability by the medical evaluator later in the year 2000. So permanent disability now raises a new wrinkle in the determination in establishing the date of injury. Can permanent disability also, like temporary disability, be used to establish the date of injury under 5412? Well, let's take a look at that idea. So we know up till now through the Wagner cases and the Wright cases and now with the Rodarty case that medical treatment can establish disability, the need for orthopedic devices can establish disability, and certainly total temporary disability, which involves wage loss, can establish disability. But the Rodarty case throws a new wrinkle and raises the question, can permanent disability constitute the disability sufficient to establish disability under Labor Code Section 5412? And the answer to that is yes. The conclusion of the Rodarty case was that permanent disability also qualifies, like temporary disability, as compensable disability sufficient to establish the date of injury. Now, with regards to temporary disability, actual wage loss is required for temporary disability, compensable wage loss, okay? Modified work alone, such as we've seen already, and especially with regards to Ms. Rodarty, she was on modified work duties, never on temporary total disability with wage loss. Modified work alone is not a sufficient basis for compensable temporary disability. For that reason, temporary disability, there is no disability established prior to the last date of employment on 8/9/98 because she never had compensable wage loss prior to her last date of work. However, and this is the new wrinkle, modified work may indicate a permanent impairment of earning capacity, especially if the worker is never able to return to the original work duties. And this is where your recommendation for work restrictions is so critical. It factors into this exact determination. If your injured worker is never able to return to the pre-injury work duties, that could be evidence of a permanent impairment, a permanent disability sufficient to constitute the date of injury and sufficient to constitute disability under 5412. Similarly, medical treatment in and of itself is not disability. And now we're starting to see some of these loose ends start to become connected, some of these dots starting to become connected. But it may be evidence of a compensable permanent disability, as may a need for splints, as may a need for modified work, all of which applied in this case. Ms. Rodarty had a need for medical treatment. She had a need for splints. She had a need for modified duty. In and of themselves were insufficient to satisfy disability, none of which constituted compensable temporary disability, but all of which, either separately and in combination, could signify a permanent disability, which is compensable disability, which is sufficient to satisfy disability under 5412. And this, we see so many of these cases where the injured worker comes to us specifically on a post-employment cumulative trauma injury claim, comes to us never having suffered temporary disability, never having received medical treatment. And they come to us, and many times it's our determination, if that examinee is permanent and stationary and we provide a permanent impairment rating, it's our determination that then establishes the compensable permanent disability, thereby establishing the date of injury under Section 5412. So with these new considerations, the matter was as yet unresolved, and in all fairness to State Compensation Insurance Fund, the matter was returned to the AME to determine if the permanent disability, the need for the braces, the permanent impairment of earning capacity, if any of that existed prior to the last date of employment. If it existed prior to the last date of employment, then a case could be made that the liability could be shared with the other insurer. So very fascinating case, important case for us as qualified medical evaluators to be familiar with, because it applies to so many of the cases that we're called upon to evaluate. And so now, in a dramatic drum roll, we see that the Rodarty case brings all of these ideas together, and we now know that disability can be many things, can be satisfied by medical evidence of a need or even a new need for medical treatment, by the need for work restrictions or modified work duties, by the prescription of orthopedic devices. We talked about two cases that involved wrist splints and wrist braces. And then certainly compensable disability in the form of temporary disability is the slam dunk criteria to establish disability under 5412. And then in the new twist in the Rodarty case, and as applies to us as qualified medical evaluators, permanent disability with diminished future earning capacity also serves as disability sufficient to satisfy 5412. And this is where we take great learning lesson from this case, because we get these types of cases in these exact scenarios all the time, where an injured worker comes to us and has had no work restrictions, has had no need for medical treatment, has had no temporary disability with wage loss, and yet it's our evaluation and our declaration of a permanent and stationary status with a permanent impairment rating that establishes for the first time compensable permanent disability, thereby establishing the disability, thereby establishing the date of injury under 5412. So in the Rodarty case, the agreed medical evaluator did not recommend additional medical treatment for Ms. Rodarty. The medical evaluator declared her permanent and stationary on the spot, gave her a permanent disability rating, and that was the end of the matter. It established the date of injury. It established the disability. Ms. Rodarty well, she did not receive her benefits because the case went back to the agreed medical evaluator one more time. But in our cases, that could be the date that establishes the conclusion of the claim, and the injured worker receives their benefits, and all the parties go on with their lives. Okay? Now, in our next session, I want to share with you what are known about cumulative trauma injury claims statistically throughout the state of California. And depending upon where you are located in the state of California, you are going to be evaluating more or less of these cumulative trauma injury claims. And when you get these cases, when your phone rings for an evaluation, I want to share with you the mental algorithm that you can go through that you will use in evaluating these cases so that you know exactly what's operative behind the scenes and what your role as the Qualified Medical Evaluator is in these evaluations. So doctors, I hope this helps you. The purpose of this entire program is to make your evaluations quicker, easier, and more accurate. And I'm sharing with you throughout this series of sessions what's operative behind the scenes that bring these cases to you for your evaluations so that you'll know exactly what to do. So I want to thank you for taking the time to join me on today's session. I look forward to being with you in our very next session as we continue our new program entitled Update on Trends in the Cumulative Trauma Injury Claim. For now, this is Dr. Perry Carpenter. I'm wishing you best of success in your career as a Qualified Medical Evaluator.